all set? And the negative team?
Yes, thank you.
All right, let's get started. Peaceful Tomorrows, an organization of more than 200 relatives of victims of 9/11, stated on April 4th, 2011, quote, "As families of those who were murdered on that day, we have waited nearly 10 years to see those who committed these savage criminal acts to be brought to justice. Military commissions have been embroiled in a series of legal challenges, and we fully expect that this inadequate alternative to our well-tested federal court system will continue to delay our pursuit of justice." End quote. What the victims were saying right then, back in 2011, holds true to this day. Military commissions have become an abject failure compared to what they were originally intended to do. Because federal courts are better than military commissions in every single way, our goal as the affirmative team is to demonstrate that military commissions should be removed as an option in order to guarantee justice both to the criminals and for the victims. I'd like to respond to the points brought up by the negative speaker in the first speech. The first, that being upstanding of a real world policy. And my simple response to addressing this is, that's what our job is, to provide a real world policy. Now, if you believe that we provide a policy that we can address, where we identify a harm and then provide a way to solve it, that's how we're presenting a real world policy. That's what our job is as the affirmative team, to propose a policy that would be able to be passed. That's our job. So the first point that they brought up was that there are impossible procedures, or impossible procedures. Yep. So the first point they brought up with this was limited charging options. And my response to this is federal courts are well equipped. Federal courts are well equipped. Now in our 1IC, my partner brought up how federal courts are well equipped to handle dangerous terrorists in the fact that nothing compares to the combination of Justice Department prosecutors, federal public defenders, and the judges and staff of the Article 3 federal courts. Furthermore, in our subpoint B of our justification, we talked about how federal courts have access to over 4,000 charges because they can have access to both military law and federal criminal law. So they encompass near 32 charges that can be tried under military commissions. And because of that, they have much broader jurisdiction. The point that they brought up, and my third response to this, is that there is no specifics. They didn't provide examples of how limiting charging options and how that was limited and how that was going to practically make an impact. The evidence was rather speculative in that regard. So their second point under impossible procedures is procedural requirements undermine prosecution. My response to this is no specifics, once again. When they brought up how there are procedural requirements, they failed to discuss what those procedural requirements were. We're not necessarily saying that their point is wrong, but if the negative team could provide some details about what procedural requirements make federal courts worse than military commissions, that would be very helpful. So the next point they brought up was that evidentiary standards undermine prosecution. And my response to this is evidence standards are the same. Evidence standards are the same. Now, when we talk about the problem of how federal courts try terrorists as opposed to military commissions, the evidence standards are applied by something under CEPA. David Glazier reported in 2012 that claims that the commissions offer legitimate practical advantages over military commissions over federal courts are mistaken. Classified evidence rules, moreover, follow evidence applied under CEPA, or the Classified Information Procedures Act, end quote. We have additional information at the table discussing how because of those reforms that were mentioned in the 1AC, how in 2006 and in 2009, the rules for the commissions were vastly changed. A lot of the standards used by both systems is exactly the same, meaning that military commissions are just a more poorly equipped version of federal courts with the same procedures, but less jurisdiction and a lower ability to actually solve their problems. So the next point they brought up was that a speedy trial requirement undermines prosecution. And my response is due time and due punishment. Due time and due punishment. Now, the piece of evidence they brought up did not specify how there was necessarily why there was a problem with the speedy trial. And of course, as my partner brought up in her last speech, just something being quick does not mean it's just. But as we brought up in our justification, not only are federal courts better in how they are more efficient and achieve punishment in due time, they achieve due punishment. When we compare two different cases of terrorists being tried in federal courts and military commissions, it led to completely different results because of the different jurisdiction in each system. We're not only working towards efficiency, we're working towards due punishment for terrorists. And those things combined are what through federal courts work. The next point they brought up was how their basic premise is that commissions should remain the option, and that the advocacy we brought up was not consistent on whether they wanted military commissions abolished or whether they wanted them reformed. Now my response is that the status quo is considered unacceptable. Regardless of what the experts said, specifically they suggested, they all agreed that the status quo is unacceptable. My second response, however, is that reforms have failed. Reforms have failed. The reason that my partner and I advocate to no longer use military commissions in this area is because when we had those reforms in 2006 and 2009, we attempted to make them unconstitutional and then actually go in line with what our prosecution should be. And there have been a myriad of reforms to try to make military commissions work better since they were established in 2001. But none of those reforms have been able to make significant impact. And because of that, there's a precedent of us trying to reform that system that's designed to deal with international terrorists. But those reforms have failed. And that's why we advocate to abandon this system, because federal courts are better. The next point I'd like to bring up is that they talked about how certain classes of cases cannot be tried in federal courts. However, my response to this is indefinite detention does not apply. The piece of evidence they brought up discussed the issue of how people who are tried under federal courts, there are certain people in Guantanamo Bay who would not be eligible to be moved to federal courts. Now, this is in fact true. As my partner established in cross-examination, there are some people held in Guantanamo who are not considered eligible for trial at all under military commissions. Those people would not be addressed through our plan. So this is a fact that the negative team is bringing up, but it's not something that we're addressing. Indefinite detention does not apply. The second response is that federal courts deal with the most dangerous terrorists. The most dangerous terrorists. Now, the National Security Division of the DOJ said on February 10th of 2017, quote, Category 1 cases involve charged violations of federal statutes that are directly related to international terrorism, including the use of weapons of mass destruction, conspiracy to murder overseas, providing material support to terrorists or foreign terrorist organizations, receiving military-style training, and etc. And it states that the chart of terrorism convictions from September 2001 to December 31st of 2016 lists more than 360 defendants classified in Category 1. And this demonstrates how federal courts have a precedent of dealing with the most dangerous Category 1 terrorists and convicting them successfully. However, in addition to due time and due punishment, I'd like to bring up one additional advantage, or another reason why federal courts have a reason to be used for military commissions, and that is international cooperation. William Finnegan reported for the New Yorker in 2017, quote, It is clear that the military commissions at Guantanamo have failed miserably. Many successful terrorism prosecutions in recent years have followed extraditions, or in other words, transfers to the United States that would not have happened if Guantanamo and its military commissions had remained an option. Our main counterterrorism partners, including the United Kingdom, Canada, Germany, and the Netherlands, refuse to provide evidence or cooperate with extradition requests unless the suspect is retried in a federal court. So what we guarantee through our plan is that we use the system that works. Federal courts have a precedent of success. They issue due punishment in due time, and they guarantee international cooperation, something that can happen under the current system, but we guarantee will take place when we pass our plan. For the sake of giving justice both to the criminals and for the victims, we urge an affirmative decision. Well, it's a complete lack of closure. When we talk about who is affected by people who have not been convicted in Guantanamo Bay, it's not simply the families of the victims, it's the entire nation that has not brought closure to the fact that military commissions have failed to reach convictions.
And so has the United States suffered because of that?
Yes, absolutely.
Okay, great, thank you. Now, your partner asked for, I believe, all of the evidence that I read. After this cross-ex is done, may I please have that all back?
Sure, yeah,
Awesome.
I can get that back to you.
Thank you so much. Now, you read a piece of evidence talking about SEPA. May I please have that evidence as well?
Sure. So I actually paraphrased it because I forgot to bring it up with me, but I have it right back with me here, so I'll pass it.
Okay, awesome. Yes, thank you so much. Now, you would agree that in a federal court hearing, the prosecutor has or may have access to some kind of classified intelligence?
Correct. However, we have some stuff at the table talking about how in interest of national security, exceptions can sometimes be granted if that were an issue, and we can bring that up in a future speech.
Awesome. Okay, great, thank you. Now, you talked about, in response to the burdens of needed advocacy, that the status quo is unacceptable. You still didn't provide the difference between opinions, did you?
What we basically stated in response to that was there was a myriad of different opinions about what these experts proposed, but what they all agreed upon was that the status quo is unacceptable.
So, You didn't provide any specific, details in whether or not they said it needs to be reformed or abolished, correct?
Well, again, they provided a number of different details, but
Okay.
also because reforms have failed in the past, what we advocate is the affirmative team is to no longer use them, because federal courts are
Okay.
better in this situation.
Great, thank you. Now, to change the status quo or the current system, sometimes all you have to do is to make a small, simple change, correct?
Yeah, this is a fairly small, simple change.
Okay.
because We already have federal courts established.
Great, thank you. Now, you talked about category 1 cases, I believe,
Right.
and the convictions and how they were successful.
Yes.
May I please have that evidence?
Absolutely.
Okay,
This is right.
great, thank you so much. Now, the real world, talking about real world policy. Now, we can agree that in my speech, I was talking about how in order for a policy to be considered a real world policy, that you must have advocates who completely and wholly advocate for your plan and all the specifics of your plan.
I don't think that's a standard that's normally held. We're
Okay.
trying to propose a policy, and
Right.
we're trying to demonstrate to the judge why it should be passed. I don't think that standard is normally put.
Okay, but you would have to, it would be generally considered wise to have people advocating for the specifics of your case, correct?
We provided reasons why the advocacy applies, and that they all
Okay.
agree that the situation should be reformed.
Okay.
That's the main premise of the advocacy.
Awesome, thank you so much.
Thank
Any
you.
questions?